You're watching 13 WMAZ Law Call, sponsored by Macon law firm Reynolds, Horn, and Servant. Your rights, your calls, live. This is 13 WMAZ Law Call.
Well, hello and welcome to Law Call. I'm Morgan Dukes, and if you have legal questions, and particularly tonight we're talking about medical malpractice claims, then you're at the right place at the right time. Please allow me to welcome the one and only Mr. Carl Reynolds from Reynolds, Horn, and Servant. How you doing, Carl?
I'm great, Morgan. How are you?
Oh, I'm doing good, feeling good, enjoying the holiday season.
Well, I understand we have some good email questions tonight about medical malpractice, and I have my partner and friend, BJ Servant, also our lawyer's lawyer on the show to help us answer some of those questions. So
good to be here.
Hey, let's get right to it.
Let's do it.
Hey, BJ, good to see you.
Good morning. How are you?
All right. I am good. I am good. I am ready to give you those questions, those email questions, so you guys can give the people some good answers. Our first question comes from Rashonda, and she has a question about the times that we're living in. Her question is, if you go into a hospital and end up catching COVID or some other kind of illness that you didn't have when you went in, can that be considered malpractice?
I would doubt it. I mean, it's kind of like an infection that you get in the hospital, whether you get MRSA or some kind of infection. It's just there. It's a risk of going in. I guess there could be a breach of some protocols that might raise an issue of fact about it. But more likely than not, I would say it is not a medical malpractice issue. What is your take on that, BJ?
Yeah, you're right. The legislature passed a law back during the pandemic that you might have noticed. You go in businesses now, they have a big sign on the front door that says, pursuant to such and such a code section, we're not responsible if you catch COVID. So you see those because if the law says if you have that on your front door, they can't hold you liable or sue you for getting COVID. Whether that's enforceable or not is another question, but you'll see that outside.
Okay. Well, let me ask you this. What if you go in there, they have the sign on the door, and they, have people in the ER who are admitting people, and they know that they have a COVID patient in a room, and you are elderly and have comorbidities, and they take you and put you in that room with those people. Does that take that beyond the statute passed by the legislature?
Well,
or are you a prisoner of that?
No, I think the statute also provides, as I recall, there's a heightened level of care or culpability you have to show. So if they're negligent, maybe not, but if they did something more egregious, you may be able to hold them accountable.
So it's almost like the emergency room statute.
Right, similar to that.
A showing of not even slight care.
Right.
And Morgan, that brings us to another question that BJ raised, the issue of the legislature and our General Assembly, who back in 2005, I believe it was, BJ,
right. Yes.
Passed a bill that said that in order to hold anybody performing emergency room work or emergency procedures was held to a much higher standard in terms of proof of negligence. You had to prove gross negligence. And it's hard enough to bring a malpractice case to start with. The thing that defeats them mostly is that it is so time intensive, it's so expensive, it's emotionally trying to bring forth a medical malpractice case. And there are many medical malpractice cases that never see the light of day because they don't involve sufficient injuries or damages. And that's a sad state of affairs.
Well, now back to BJ's point with the sign that's on the door. I see that in businesses everywhere. If you should happen to get COVID as a result of going into one of those businesses, wouldn't it be very, very difficult to prove?
Yeah, that's my other point. Carl's exactly right about that as far as whether you have a case or not, because you still have to prove it. You have to prove they did something wrong. And that would be very difficult because who's to say you didn't catch it at a prior store or from a relative at your house or any other number of sources. It'd be very difficult to prove. unless there was like an outbreak at that one facility. A lot of people caught it.
Oh, okay. All right.
I mean, just because you could bring a suit doesn't mean that you can go to trial and get before a jury. The safeguard in all of those situations, if you bring a suit, you know what they say, you can sue the Pope for bastardy, but you still got to prove it. Now, just because you bring a suit doesn't mean you have the right to go before a jury. And the safeguard is that the defense in those cases can file what is known as a motion for summary judgment, meaning there's no real issue of fact. So the court, that is the judge, will look at it and say that under the law and under the facts, as I've heard them, this is simply not a case, and then he enters a judgment for the defendant. So that's just part and parcel of what we're talking about.
Well, on that note, should businesses be asking you to sign a waiver? I've experienced that too. They want you to sign a waiver before you come in or experience their services. Is that legal?
BJ?
Well, it depends what type of waiver you're talking about, Morgan. If it pertains to COVID, I think the sign on the door would be sufficient for the business, and probably would be overkill if you sign something similar saying the same thing. Other businesses, if you're talking about waivers in context of you go to a skating rink or a baseball game or an amusement park or someplace where you might get injured and they ask you to sign a waiver, those are enforceable under certain limited circumstances, but they're very factually specific and dependent. So whether one of those would even be enforceable or not, if you got hurt, you could probably still sue.
Okay.
Well, normally you cannot waive, a business can't get you to waive prospectively an act of negligence. That's simply not enforceable.
Okay, I see. All right, well, that's good to know, because that's happening in a lot of places now that I've experienced, where they want you to sign some type of document or indicate that you won't hold them accountable or responsible if you fall victim to COVID. So that's important to know. Okay, well, I'll tell you what, I'm talking with Mr. Carl Reynolds and BJ Savant, both of Reynolds, Horn, and Savant, and we're going to take a quick break. And when we come back, we're going to get into questions about what happens if you take the wrong medication. Is that a claim for a malpractice suit? Somebody wants to know, and hopefully we can have them an answer when we come back. I'm Morgan Dukes, and you're watching LawCall.
You're watching Law Call on 13 WMAZ with personal injury attorney Carl Reynolds, who has recovered more than $500 million for his clients, dedicated to helping injured Georgians for more than 50 years, plus support from his Macon law firm of Reynolds, Horn, and Servant, including attorney Wendell Horn, focused on protecting the rights of car and truck wreck victims across the state, and attorney BJ Servant, aggressively representing those injured by medical malpractice, hosted by award-winning broadcaster Morgan Dukes, featuring guests from across Middle Georgia. Your rights, your calls, live. This is Law Call on 13 WMAZ.
And welcome back to Law Call. I'm Morgan Dukes, and with me tonight I have from Reynolds, Horn, and Servant, Mr. Carl Reynolds himself and BJ Servant. And tonight we're discussing a very important and very interesting topic, medical malpractice. Sometimes it happens, and you need to know what to do if it ever comes your way. So, gentlemen, we do have a question here from Melissa. And her question is, I was misdiagnosed and was on the wrong drugs for months. It was only during a second opinion that I found the error, and the doctor is refusing to take responsibility for his actions. Melissa wants to know, do I have a medical malpractice case? Does she?
Well, Melissa, it depends. As Carl mentioned, these cases are very expensive and very time consuming, and you need to have substantial damages before they're economically worth pursuing. In this instance, where she has the wrong medications prescribed for, it's not clear from the question what that did to her. She took it and didn't really have any problems, and of course, there's no damage. If she suffered some sort of harm, perhaps she took a medication that made her pass out when she wasn't expecting to and had a bad wreck, that may be something. But if it just made her feel uncomfortable for a little while and she found out she had the wrong medication and then it's corrected and there's no damage, then it probably wouldn't be a case. And of course, there are always going to be the user error. In other words, the patient has to look at what she's taking, and the defense in that case would argue that she should have noticed it was wrong medication. If it was a clerical type error, if it's the type of medication prescribed by the physician, of course, she wouldn't know, but sometimes fault contributes, figures in cases like that as well.
So since it's, you mentioned something very important, it has to be absolutely catastrophic at some point for it to really be worth your time. So what do you do if you have some type of damage along the way?
Well, a number of things you can do. I mean, there are a lot of cases where there is a malpractice or substandard care given, but the damages or the injuries and the damages don't rise to the level that you can justify proceeding with a civil action. That's what we're talking about. You can always file a complaint with the composite medical board of your state. You bring it to their attention and hopefully it will do some good. They will investigate each and every case. And even though the injuries caused were not sufficient to justify a medical malpractice lawsuit, it will be investigated. And then if others do the same thing and the culprit is the same person, it will add up and action will be taken. From moderate to severe, depending on, the frequency and the kind of events. And let me just say real quick that, we are lucky in this community. Almost all of the doctors I've ever interacted with are excellent physicians. The people in the hospitals here are professional, well-trained. They are compulsive, they are vigilant, and they do really good work. Now, that said, every now and then you have a situation that arises that's unusual, and the results are catastrophic, as you say, Morgan. Mm-hmm. I know we had a case years ago actually it was in Asheville, North Carolina, and it involved a 2-year-old baby who was put in the hospital for an illness, and they wanted to put him on a normal saline solution, an IV drip. And the doctor, for whatever reason, thoughtlessly or overworked or hungover, I don't know. We never found out. But he wrote his order to give this child 10 times what was appropriate in the way of an IV infusion. Both parents were with the child all night long. The child began to display symptoms consistent with brain swelling and overhydration. The parents called repeatedly to the nursing staff on the floor. And what they got was the doctors know best, they know what they're doing, et cetera, et cetera. Now, the end of the story is awful. The child had brain swelling, had multiple seizures as the swelling increased, and eventually died. And we brought that case there. We sued. I can say the name because it's a matter of public record. It was Somerville versus Volk, V-O-L-K, was the doctor, and Mission Memorial Hospital. The nurses, and the reason the hospital is named is this: the doctor wrote the wrong order. He gave 10 times more fluid than was appropriate. But the nurses, and this is kind of like the story BJ was telling, it's who's at fault? Where was the mistake made? And should it or could it have been caught by somebody down the line? In that case, the nurses should have known that this order was highly inappropriate and erroneous. And yet, rather than thinking about it, looking at it, or going to their charge nurse, they just tried to satisfy the parents by saying they knew what they were doing. That resulted in a pretty substantial verdict for those parents because of the wrongful death of that 2-year-old. And when we talk about catastrophic or wrongful death, that case went over, 4 or 5 years to get it to trial. One of the nurses had actually left partly on account of this situation, and we had to go I think way up into Western. I think we actually went to Alaska to do her deposition and bring it back and try the case. So as you can see, it's a long process. It's terribly expensive, and you have to have really significant injuries in order to justify bringing a medical malpractice case. So a lot of them just simply don't rise to that level.
Another interesting aspect about that case, Morgan, as I recall, the doctor actually became a witness for us and saying that the nurses should have caught what he did wrong.
Yeah.
Wow.
During the trial, he said, "This was my error," and he was decimated by the fact that he had done it and it caused what happened. But he did testify that should have been caught by the nurses. He should have been called. They should have taken it to the charge nurse. And if the charge nurse didn't do anything about it, take it to the hospital administrator. I mean, they have duties and responsibilities too.
Absolutely.
I always preach this: when you're in the hospital, and I was there recently. Most people know I had a bad wreck about 6 months ago, and unfortunately had a broken neck, and I was in the hospital for 2 days. They took great care of me. I got nothing but accolades for the hospital, the nursing staff, and the physicians I had. But that said, and outside of this COVID era, if you're in the hospital, you need a patient advocate with you. Unfortunately, it didn't do any good in that case, but I would say that to anybody who's in the hospital.
Okay. Well, is that doctor still practicing? Yes or no?
Yes, he is. I mean, he's a good man. He made a mistake. He made a mistake, and he accepted responsibility for the mistake that he made. That's very rare in medical malpractice circles.
Yeah, we had a case where the doctor operated on the wrong leg, and he wouldn't admit he did anything wrong.
Oh my goodness! Yeah. I've heard of those cases too.
The guy went in for knee surgery of his right leg. Yeah. Okay, they operated on his left leg. It took us 3 years to get to trial, and their defense was, well, the left leg needed it anyway.
Oh my goodness. Okay. All right. Oh boy. Well, on that note, we're going to take a quick break and come back with more medical malpractice questions, because, if you're in a situation where you need to be in the hospital, you don't want anything to go wrong. I'm Morgan Dukes, and I'm with BJ Savant and Mr. Carl Reynolds of Reynolds, Horn, and Savant, and we'll be back with more of LawCall next. If you have questions for Carl Reynolds or BJ Savant, you can find them at Reynolds, Horn, and Savant right here in Macon. Their telephone number is 478-405-0300. You can also find them on the web at www.reynoldsinjurylaw.com. And please don't forget to follow them on Facebook. Just look for Reynolds, Horn, and Savant. Gentlemen, it's good to have you both with us tonight as we are getting into some sticky area here with medical malpractice. It's good to know what to look out for, what you can sue a doctor or a hospital for, and what you can't. This has been some good dialogue. In fact, Bonnie has a question. She sent in her question by email, and it's in reference to her grandfather and lung cancer. Her question goes like this: my grandfather died from lung cancer last year. He had been sick for several years before he was finally diagnosed. I think the doctor screwed up and should have diagnosed him earlier. Then maybe he would have had a better chance at survival. Can you sue over a misdiagnosis? That's a good question. Can you?
Well, BJ, why don't you start with that, and then I'll chime in.
Yes.
Yes, you can. Yes,
that's the short answer.
Just like the question.
You can sue for a misdiagnosis case. There's just a lot of issues within that. And I thought Carl would explain that.
But Morgan, it's a very difficult question to answer in this format. I mean, there's so many variables in it. How aggressive is the cancer? How rapidly does it grow? How much was the delay? Did the delay cause any additional damages, or did the delay actually result in death? I had a case one time where there was a delay in diagnosis of a year. It was a cancer that was in the neck of the bladder. It was clearly missed. It was seen radiographically and the doctor missed it. It went for over a year. But as it turns out, there were no damages because when they finally diagnosed it and took the appropriate steps, which unfortunately resulted in the loss of the man's libido, at the end of the story, what you've got is he had a year longer sex life than he would have had they found it to start with. So yeah, you got to have injury and you got to have damages. You know, no harm, no foul, no damages, no lawsuit. There are other cases where you have a delay in diagnosis in breast cancer. Because of the delay, then you develop metastatic disease and it becomes incurable and fatal. And of course, yes, then you do have that. There are other cases where the cancer is so aggressive that even though there is a delay of a month, 2 months, 3 months, it wouldn't make any difference because the cancer has already metastasized. So that's a very complex, that's a simple question that requires a lot of complex detail to give an adequate answer.
And everything Carl said, Morgan, is based on expert testimony. In a cancer case, you have to have, you know, a doctor criticizing the timeliness of the diagnosis, but you have to have an oncologist who will relay to the jury what the treatment would have been if it had been discovered sooner, what difference it would have made. And those are all medical issues or medical opinions that you need in a medical malpractice case. What you think is misdiagnosis doesn't matter. It's what a doctor says is misdiagnosis.
Yeah, well, that's a very fundamental thing we often overlook in this show because we try to simplify the answers. But when you talk about medical malpractice, you're essentially talking about professional negligence, whether it's a medical doctor, an engineer, a lawyer. There's a whole list in the Georgia Code of professions that are subject to this Professional Liability Act. And in order to bring a lawsuit on any of those, you have to have an affidavit for somebody who is competent in that profession to say that the professional was negligent in some way, or you can't bring a lawsuit to start with.
Oh, okay. Well, that's important to know because, you know, we're getting into the holiday season now, and sometimes people want to just bring up lawsuits for whatever reason. You know, sometimes it's to gain a little more money, sometimes to gain some popularity, sometimes to, you know, just bring up something. So it's good to know that you got to have a lot more to it than just the idea of suing somebody.
Well, that's not to say, not to take issue with you, Morgan. I wouldn't do that. But I don't think there are any spurious lawsuits in medical malpractice. There's just too much involved, too much cost in so many areas that you don't see any spurious lawsuits, in my opinion, in the field of medical malpractice.
Well, thank you for clearing that up for me. Listen, gentlemen, thank you so much for being here with us tonight. I'm Morgan Dukes. Until next time, good night from all of us here at LawCall.
Good night.